pick up something surprising that the Italian David said towards the end regarding the need for a standard by which you advise other governmental agencies. So you both agreed that there is no or should be no governing standard or parameters or specific methodology for that, which I find surprising, given that A, the authority is called upon to give advice and advocacy both generally and especially in specific cases. B, a lot of government agencies and courts also, or administrative agencies, approach the antitrust authority and ask for their opinion on specific cases, and often, very often, act upon that advice. I would say that the advice that the competition authority gives in these cases is presumptive for what will happen. It is very rare that another agency will then ask for advice and then not do what the competition authority says. It happens, but rarely. Or in other words, the competition authority has a lot of actual power in giving this supposedly informal advice. And when you have a lot of power and you have no governing standard, that sounds to me pretty dangerous. And it's connected to the case, the topic of this panel, because one of the things we were talking about, and Michal was stressing before about the economic concentration law, is that we don't have a very specific methodology, and a lot of work was put into trying to devise such a methodology, which is still, let's call it in the beginning stages. So the antitrust authorities getting more and more power vis-a-vis decisions affecting the economy. And in this whole area, you don't want it to be limited by some governing standard. It sounds to me like opening up a lot of power with very little responsibility. And maybe I misunderstood something, but I'd love to hear your thoughts on that.